Good morning, everybody. Grant Adlam from KZN Top Business and KZN Top Business Masterclass on some very, very important topics, POPI, PAIA, and CPA. I was having a chat to one of our gurus, Johan van Deventer, who wrote an article on the POPI Act in one of our publications not so long ago, and the inquiries were absolutely incredible. It was read like you won't believe. So Johan and myself decided to put together a team of gurus who specialize in that. So there the gurus are. So we've got James, Yana, and Samantha, who are sitting there around the boardroom. Hi, everybody. You can unmute there so we can hear you.
How's it going?
Hi.
So basically what we're going to do is we're just going to jump right in the deep end, because we got the three, because you can't call you wise men. What's the word we would call you? Wise everybody. The wise team. So when it comes to the POPI Act, PAIA, and CPA, we got the three specialists sitting around the table. So the way we're going to do it is I'm just going to give you the reins, do your presentation, and afterwards what we want to do is try to make it as interactive as possible, because everybody needs to know what we don't know about these three important things. The POPI Act is, how do we collect it? What do we do with it? Where do we store it? How do we destroy it afterwards? Where and when? All these incredible, easy things, or hard things for us, easy for you, you're going to fill us in on. So I don't know which order you're going to go in, but I'll hand the floor over to you.
Thank you so much. So as mentioned, we're going to take you through POPI, PAIA, and the CPA today. My name is Samantha, and I'm the National Information Compliance Manager. And with me, I have James and Yumna, who are both information compliance team leads in my department at LabourNet. I'm going to be handling the POPI side of things. James will be taking us through PAIA a bit later, and then Yumna's going to finish off with the CPA. When we're putting this together, it becomes quite tough, because what is important to let you know, POPI is a complicated act. It's a tough one to handle. So what I'm going to do is I'm really going to touch on the basics that need to be in your business right now to make sure that you're avoiding any penalties or fines or anything like that. So let's start off with what POPI is. POPI is the Protection of Personal Information Act, and POPI is actually not a new act. POPI was government gazetted in November 2013. However, not all the provisions were brought into play back in 2013. They sort of trickled in over the years, and we had the final remaining provisions signed into power on the 1st of July 2020. We did have a year transition period to become compliant with the Act. So as at 1 July 2021, the information regulator has full powers to investigate and fine us if they find anything wrong. So one of the big misconceptions with POPI that I want to jump in right off the bat with is I often hear people telling me, well, they only really need to be compliant when they collect personal information. And that's really when people are putting majority of their effort. And yes, that is true. You've got to be compliant in the collection phase. But in actual fact, you need to be compliant in the entire life cycle of personal information. So yes, we must have consent or a justification when we collect it, but are we using it in line with our specified purpose we told the people we're going to be using it for? Are we storing it securely? And then how are we handling the deletion or the archiving of the information? As all of these elements must be compliant with POPI. And that's really where I see the biggest mistakes being made at the moment is everyone's putting their effort on collection and, for example, nothing on use or storage. So what is personal information? I've put here the full definition for your personal information. This is directly out of the Act. I don't expect anyone to know this off by heart, but I really wanted to show you how much broader the term personal information is than we actually think it is. So as you can see from this, we obviously have qualifying criteria. So they've told us that personal information means information relating to an identifiable living natural person or an identifiable existing juristic person. So here we've got an interesting thing. Yes, natural people like you and me, our personal information is protected, but so is juristic entities like LabourNet, for example. LabourNet's personal information that belongs to the company is also now protected in terms of POPI. And this is really one of the biggest differences we see between POPI in South Africa and the European legislation, which is the GDPR. They only protect natural persons' information. So we actually have a higher threshold in this country to comply with. Now, as you will see, personal information can be anything listed here, or it can also be additional things as long as it meets the criteria that it relates to an identifiable living natural person or an identifiable existing touristic person. So my personal favorite from this is if you go all the way down to subsection E, the personal opinions, views, or preferences of that person are even protected. So if I do a survey, that's protected. And then if you look at subsection G, the views or opinions of another individual about that person. So my performance review, for example, will also be my protected personal information. So it's really not just ID number, email, home address that we think it is. Can be so much more: sexual orientation, age, physical or mental health. It really does extend beyond those borders. So we just must be making sure that we are classifying personal information correctly and protecting it if it meets the requirements in terms of this definition. So the way POPI is set up and built as an act is it's really based off these 8 main conditions. Yes, there are some additional obligations later in the act, but that's really for specific processing or specific activities that you're doing with the information. Everyone must comply with these 8 conditions. I have put the section numbers up here if you would like to go look at them. You'll see in some instances, multiple sections relate to a condition. So accountability is really about getting whoever's holding that personal information or collecting it to be accountable and actually do the right thing with that information. Processing limitation tells us when we can collect, when we can use, how we can use it. Purpose specification sets out that you must have a specified purpose for processing the information, using it, collecting it, etc., and that must be communicated. Further processing limitation lets us know when we can use personal information again. Information quality speaks to exactly that, the quality of the information. It must be up to date and accurate. Openness is where we then become transparent as a business to let people know what information we have about them. Security safeguards is all these measures on how we actually protect the personal information. And then we have the data subject participation, which actually allows the data subject to contact you and ask what personal information you have about me, and they then can correct or delete it. So I have rushed through this a little bit, but it is very, very in-depth. So from these 8 conditions, I'm going to highlight the important things that we really should be focusing on as a business right now. So your basics, your information officer, your consent or justification, your operator's agreement, your security measures, and your training. So the first point there is your information officer. Every legal registered entity needs an information officer that has been registered with the information regulator. And in fact, the way the legislation is set up is you will automatically become an information officer if you're the head of your organization. So if you try to avoid penalties or things like that by not registering yourself, it automatically attracts to you. That only means you're going to get punished once for not registering, and then again for breaching POPI. So you're just making it worse for your situation in any event. So my biggest recommendation is go onto the information regulator's website, register as the information officer for your organization, and everything is on their website as to how, when, where you submit the forms. It is a very, very user-friendly website. Then when we speak about consent and justifications, consent here, I want to pause and actually speak about what consent is in terms of the act. So in other acts, you can have consent in terms of silence. So if I don't object, you can take it as my consent. However, with POPI, that's not how it works. So POPI's defined consent to be voluntary, informed, specific, and an expression of will. Voluntary is not new. Obviously, we cannot enter into a contract under duress. Informed and specific means I must know what I'm consenting to. And then the most important there, the expression of will. I need to actually do something to give you my consent. Tick a box online, sign a contract, say yes on a phone call. I must do something in order for you to get my consent. So if you're sending out consents and say, well, if you don't respond within 7 days, we're going to deem you have consented, that is not correct consent in terms of POPI, and it will be invalid. Now, you don't always need consent in terms of POPI. It is the preferred method. Specifically at LabourNet, we prefer the consent route. However, you can utilize the justifications given to you in section 11 of POPI. And I'm just going to speak about two of them, which are the most applicable to the general businesses that we deal with. And the first one is to conclude in terms of a contract. So when you hire an employee, you don't need their consent to collect their personal information, because you need their personal information in terms of the contract for them to work for you. You need to be able to call them, tell them where to be, etc. So in that instance, you don't necessarily need consent. But there are sometimes what we call special personal information that requires consent. Biometric access for employees is one of them. So if you do have biometrics, then you will need their consent to collect their biometric information, but not their name, because you've got a contract. Okay. The second justification is to comply with an obligation imposed by law on the responsible party, so on us who's holding the information. The best example I can give you is the Department of Labour. When they walk in and they want to do an audit or an inspection, often my clients say, well, I'm not giving them my employee information because that's a breach of POPI. No, don't do that. You are going to get in trouble, because the Department of Labour is empowered by legislation. So there's legislation that says you have to hand over this information. So whenever there's a law that requires you to share information, collect it, store it, you have to follow that law. POPI will actually take a back seat to it. Okay. Then, as I mentioned, there are specific times we need consent. One of them is a trans-border, when we share information outside of South Africa. You need consent. And then if you're dealing with special personal information, so health information, biometric information, children's information, we need consent from the guardian or legal parent to work with. So there are instances where we definitely need consent, and that's why for us it's easier. Let's just get consent for everything from the get-go. The other thing you're going to need consent for is marketing to people who are not your clients. If you have their consent to process their information, that still doesn't give you the right to market to them. That's two different consents. So please just watch out for the marketing, but I will touch on it later on. And then finally the data subject notification. When we collect information, we need to inform the data subject that we have the information. This is what we're going to do with it. This is how we're going to protect it. There's a whole range of things we need to tell them. So please just make sure if you are collecting information, at some point you're going to need to tell that person or that company that you've got it. Okay. Then we can look at the operator's agreement. So an operator's agreement kicks into play when you make use of an operator. An operator is someone who processes personal information on your behalf. You don't have control over them. They're an outside third party, not an employee. So for example, if you've got an outsourced payroll or IT or marketing or HR, they're going to be operators because they're using your employees' information, for example, to run the payroll. You have to have a written agreement in place with these people. And the companies that you're using, and the 4 main clauses that you need in the agreement are listed here. So the operator must make sure that they keep all information given to them confidential, and they must not disclose it. They must accept that they will meet the security requirements in terms of POPI. Thirdly, that they will inform us of any breach that is to happen to the information. So if it's fallen into the wrong hands, they need to let you know. And then that they will only process that personal information with your knowledge and within the mandate you've given them. So those are the 4 requirements there for an operator's agreement. And you'll see I've got a big warning there on the screen. Please read your operator agreements that you are getting. We are seeing very funny things that people are trying to slip into agreements that we often overlook. One of them that I keep seeing is that operators or responsible parties are putting in a clause that allows them to come to your premises and inspect your premises during working hours, inspect your systems. They have full access to everything in order to audit you whether you are POPI compliant. That's not required in terms of the legislation, so you do not have to agree to it. Okay. Then in terms of our security requirements, this is actually almost what I've got here word for word out of the Act. And this is really all POPI tells us to do. They've given us this objective, but they don't quite tell us how. So they've said that the responsible party, being us who holds the data, must ensure the integrity and confidentiality of the personal information in our possession, by putting the appropriate and reasonable technical and organizational measures in place to prevent the loss of, damage to, unauthorized destruction of, unlawful access to, or unlawful processing of the personal information. So you'll see we've got a whole bunch of objectives here. We can't lose it, we can't damage it, we can't allow someone else to access it. We then have to design our routes on how we get there. By them saying we must take technical and organizational measures, they are telling us we must protect both our IT and our soft copies as well as our physical records that we hold. So some examples of how to implement this in your organization. It's two real ways. You can do it via organizational measures and IT measures. We generally do it with a policy framework because POPI wants a change in behavior. Policy dictates behavior in companies. So, for example, organizational measures you can use, the data protection policy, that will dictate how you use personal information, when, what your processes are. A clean desk policy, put sensitive information away at the end of the day. Lock your computer screen when you walk away from it. Physical security policy, is there an alarm in the building? Can they just break in and get your records? When we look at IT measures, one of the first things I like to put in place is a password policy that stipulates you've got to have a password on your computer or your phone, when we have access to these types of things, and we can then set the minimum requirements for that, 4 characters or 5 characters, whatever it may be. The minimum access policy speaks to when we allow certain devices on our network. So what minimum things must be on this computer in order to join the network. And then it also speaks to don't give everyone access to everything. In an organization, there's no reason why I need access to the full LabourNet payroll. Yes, I need access to my department so I can process that, but I don't need to have access to every single person in the company. So in that way, we minimize the risk of something happening to that information. And the third policy there is your server policy. How is your server regulated? How is it protected? Do you have firewalls and all those types of features? So we really have a lot of free rein here as to how we're going to do it. These suggestions that I've made are aligned with international best practice as well as your ISO standards, which is your IT requirements. That's a whole different standard. So my best advice is align with international IT best practices and then organizational best practice as well. And then you should be okay in terms of your security requirements. Now, the one area which I think is a massive risk, particularly for all of us really, anyone running a business, we need to market, we need to sell, that's how we survive. But how that happens now has changed. So POPI has brought in strict conditions for the lawful marketing. And it is, as I mentioned earlier, a separate consent to just the normal processing consent. So you can essentially, if someone is your client and you gave them a reasonable opportunity to object, you can continue marketing to them. But when we start speaking about this cold emailing or anything like that, POPI is going to require you to have consent. You must take into account the other acts that affect this area, which one of them being CPA, which Yumna will chat to you about in a bit. Because CPA regulates how you market telephone calls and things like that. POPI regulates any electronic marketing, so emails, SMSs, WhatsApps, that type of thing. So you must take both into play. Just know no cold emailing is allowed. We need consent or they must be a client of ours. Okay. When we speak about investigation, so what is going to happen if I do something wrong? Well, the information regulator is really the governing body of POPI, and they're going to be the ones that enforce it. So they can either just come and do a random audit, or most probably someone would have complained. So if you market to me and you don't have my consent to do so, you go onto the information regulator's website, you fill out a quick form and your complaint is in. So it's very, very easy to lay a complaint against a company. That means it's very, very easy for us to go under an investigation. That's why we've got to be careful what we're doing. Make sure your information officer is registered and make sure your PAIA manual is uploaded to your website. But James will chat to you a bit about that later, because those are your biggest areas that are going to show you're not being compliant. If they don't have a registration form on file, well, then they know you haven't made any moves. They can go straight to your website and see if you've got a PAIA manual as well. So there is easy ways for them to find out whether we're complying or not. Okay. The best advice I can leave you with is treat personal information like you treat your money. Get consent. Don't forcefully take money from someone. Don't take their personal information. Get consent or have a contract in place so you're covered. Have minimum access measures in place. You know, you don't leave your money lying around. You don't show it to anyone. You don't share it. So, or maybe some people share it, but for this example, don't share it. Put security measures in place. Look at what can happen accidentally. What can happen if an employee maliciously sends out our information. Protect what has been entrusted to you, really. And put limitations on your processing. Only use the personal information for what it was originally consented for, so our original purpose, and have an accounting sort of system within your business that sets out when and how, essentially your data protection program. There is a lot of things that have happened accidentally in the last 6 months in terms of data breaches where information has been leaked. A number of big businesses have had leaks and they are under investigation at the moment. So this is also an area that if you're having leaks, because you have to report it to the information regulator, that you may find yourself under investigation. And that brings me to the end of my section. Obviously, we'll get to the questions later, but I do have my email address here if you would like to engage a bit afterwards on anything else I can answer for you before I end the session. But then I will hand over to James to tell you all about PAIA.
Thanks, Sam. So yeah, as you know, a lot of people have been talking about POPI. It's the new trendy act that's come out, but PAIA has been around for a lot longer and they kind of go hand in hand together. So what is PAIA? PAIA is South Africa's access to information law. It enables people to gain access to information held by both public as well as private bodies. So essentially what that's telling us is POPI tells us how not to share personal information, and PAIA comes in and tells us when it's okay to do so. This will also include company records over and above personal information. The requirements in terms of PAIA is essentially you need to have a PAIA manual. It needs to be publicly available. Typically, this is achieved by having it available on your website as well as in your reception. Over and above that, we are also required to have PAIA guides, which essentially break the PAIA manual down as well as the PAIA Act down and explain it in multiple different languages. So as long as we have that in at least 2 different languages on file, ready to go, we are pretty much all good. It's essentially, we need those PAIA guides in order to explain the manual when it's difficult to understand for people that don't understand it, if that makes sense. I know it sounds a little bit silly, but it can be difficult to understand. There's a lot of big words in a PAIA manual, and those PAIA guides just nicely simplify it and break it down. I tend to always suggest, instead of just keeping 2 of the PAIA guides, rather just keep all of them that are available. That way, if there are any changes in future, we know that we are covered going forward. How do we know if we need a PAIA manual? So previously we used to run a 2-step test. We would first ask, do you have more than 50 employees? If the answer to that is yes, then automatically we need to implement a PAIA manual. If you answer no, we go on to the second stage of the test, which is, do you exceed the turnover thresholds that are listed there? This exemption fell away on the 31st of December last year, meaning all companies now do require a PAIA manual. What needs to be inside your PAIA manual in terms of a private body? So firstly, we do need a postal address, a street address, phone, fax numbers, an email address of the head of the body. A description of the PAIA guide published by the South African Human Rights Commission. So typically, previously, the PAIA Act was governed by the South African Human Rights Commission, and then last year when the information regulator and POPI came into play, it switched over to the information regulator. But we are still required to keep that description of the guide in every single PAIA manual. We need to have the latest notice, which is found in section 52, subsection 2 of PAIA, a description of all records which are available in terms of other legislation, as well as sufficient detail to facilitate a request for access to a record of the private body. In terms of a public body, there's subtle differences. We need to have a description of its functions and structures, postal address, street address, phone number, fax numbers, and email address of the information officers, but we also need to include every single deputy information officer that the company has as well. We need a description of all remedies available in respect of an act or failure to act by the body, a description of the guidelines referred to in section 10 of PAIA and how to access it, sufficient detail to facilitate a request for access to a record of a private body, the latest notice found that we also needed for the private bodies, and a description of the services available to the public and how to gain access to these services. In terms of making a request, so essentially this is the core purpose of PAIA, is how can I request information from your company? It fills the gap in between, as I mentioned earlier, what you can and what you cannot share with me. So I would need to firstly access your PAIA manual, which, as I mentioned, we could probably find it on your website. If you're a private body, I need to ensure that I'm enforcing a right with the document that I'm requesting. I will then get the PAIA manual from your company and fill in the attached annexures. This is not a requirement, but we do recommend it. Just simplifies the process to have everything listed there. Once I've filled that in, I would submit it to the information officer of the company and more than likely have a conversation as to why I'm requesting this information. If there's any more details, I could then discuss that with that discussion. The fees must then be paid, and a decision will be then made if the PAIA request will then be accepted or not. Once it's accepted, obviously the documents will be prepared after the fee's been paid and then sent through to myself. If you're making a request from a public body, the only real main difference is I don't necessarily need to enforce a right with that document. I can request a couple more documents on top of that as well. In terms of fees of PAIA, we always recommend the fees be listed in the PAIA manual. Once again, it just kind of simplifies the process. You don't have to, go back and forth with what are the fees here, where can I find the annexure forms? It's just all listed in the PAIA manual. The fees should always be up to date, and this can be found on the Information Regulator's website if there's any changes. No fees are applicable to a requester if they earn under a certain threshold. These are also listed online as well. I believe it's around 14,000 Rand a year. And yeah, I know that was super quick, but that is my presentation on PAIA. I look forward to any questions. If you guys do want to have more of a conversation regarding PAIA, there's my email address. You're more than welcome to pop me a mail at any time. I'm going to hand over to Yumna now, who's going to discuss the CPA.
Hi, everyone. So we've heard about POPI and PAIA, but an act that's really looked over by companies quite a bit is the Consumer Protection Act. When we hear Consumer Protection Act, we think it's really just there for the consumers, and we don't really take into consideration the various obligations that are actually placed on companies by this act. So what is the Consumer Protection Act? Before the passing of the act in 2009, consumer protection in South Africa was not sufficiently regulated. In fact, we really just had the common law. The act was therefore developed to provide a legislative framework that protects the rights of consumers. Its goals include the following: to promote a fair, accessible, and sustainable marketplace for consumer products and services, to establish national norms and standards to ensure consumer protection, to make provision for improved standards of consumer information, to prohibit certain unfair marketing and business practices, to promote responsible consumer behavior, as well as to promote a consistent legislative and enforcement framework related to consumer transactions and agreements. Who does the CPA apply to? Well, the CPA applies to all transactions for goods or services in South Africa in the ordinary course of business. A consumer can be defined as any person, which includes juristic persons, to whom goods or services are marketed, the person transacting, as well as the beneficiary of a particular good or service. A supplier is any person who markets goods or services, whilst the phrase ordinary course of business means that if a supplier sells a product to a consumer, that consumer can only enforce his rights if the supplier is in the business of selling that particular product or service. Similarly, consumer rights can only be enforced by consumers as defined. So natural persons, being individuals, or juristic persons such as companies who have an annual turnover of less than 2 million Rand. However, like with every act, there's definitely some exemptions. So the act is not applicable in respect of goods or services promoted or supplied to the state, industry-wide exemptions being granted to certain regulatory authorities, credit agreements in terms of the National Credit Act, but not the goods or services. And if I can just mention here, when we say it doesn't apply to the actual agreement, it does still apply to the services and the goods that you actually receive in terms of that agreement. So it's a bit of a double whammy there. Services under employment contracts, agreements giving effect to collective bargaining agreements, as well as agreements giving effect to bargaining agreements. While the CPA notably amplifies consumer protection, which is greatly welcomed in this day and age, the Act has also led to some unforeseen circumstances, such as increased prices, as suppliers are required to take steps to mitigate their potential losses and payments of civil judgments. The Bill of Rights has enshrined the rights of all South Africans, including consumer rights. The Consumer Protection Act further outlines these key consumer rights, all of which South African consumers should be aware. These rights include the following: the right to equality in the consumer market and protection against discriminatory marketing practices, the right to privacy, the right to choose, the right to disclosure of information, the right to fair and responsible marketing, the right to fair and honest dealing, the right to fair, just, and reasonable terms and conditions, the right to fair value, good quality, and safety, as well as the right of accountability by suppliers. When it comes to CPA compliance, we're often too focused on consumer rights and forget to take into consideration the impact that these rights have on businesses and their processes. So how can businesses become CPA compliant? Well, number one, implement policies in line with the CPA. Have policies in place to ensure that company processes are in line with the Consumer Protection Act, and make those policies available to consumers for the sake of transparency. Number two, continuously adjust your company's processes to ensure that they are in line with the CPA. Be cognizant of changes within your business and how these may affect your CPA compliance. Don't forget to keep abreast of changes to the CPA and any new precedents that may come out of our courts. Number three, follow up on consumer complaints. Monitor complaints to ensure quality control within your business. Develop policies and procedures to ensure that consumer complaints are dealt with timelessly and effectively. Number four, talk in plain language and communicate clearly. Ensure all of your communications are easy for consumers to understand. Have someone review documents prior to putting them out, and this includes your general terms and conditions, instructions, policies, including marketing material. And remember, especially when it comes to marketing, only communicate within the regulated times as per the Consumer Protection Act. Lastly, and most importantly, make sure staff are aware of how the Act affects them. Train your staff so that they're aware of the CPA, and train your staff on your CPA compliant policies and processes within your organization to ensure that they can handle any situation that they may be faced with. But why does the CPA matter? And why do businesses need to be compliant? Well, seeing that businesses are primarily designed to serve their consumers, the CPA is at the forefront of legislation governing businesses and ensuring they operate legally and ethically. Therefore, businesses should make a point of familiarizing themselves as well as their employees with the Act, because a failure may result in some of the following. Businesses could expose themselves to litigation from consumers, whether or not they were aware of their non-compliance with the Act. Failure to adhere may cause severe damage to businesses' reputation, particularly with social media having a significant effect on people's views, which in turn could have a devastating impact on the size of the business and profitability. Consumer service is also key to staying ahead of the competition. By respecting the rights of the consumers, a business can build a reputation for consumer service excellence, thereby attracting more customers, especially as we exit the pandemic. It's clear from this that we see the manner in which businesses treat its consumers is therefore paramount. So who may lodge consumer complaints? Well, any individual, an authorized person acting on behalf of another, a person acting as a member or in the interest of an affected group or class, or a person acting in the public interest. But what happens when there is a complaint? Where does this complaint go? And who may a disgruntled consumer or group of consumers go to? Well, there are a number of dispute resolution bodies available for them. There is the applicable industry body, an applicable industry ombudsman, National Consumer Commission, the National Consumer Tribunal, or once all their avenues have been exhausted, any court with a relevant jurisdiction. But what is the consequences of failing to comply with the CPA? Well, any person convicted of an offense is liable for a fine or imprisonment for a period not exceeding 12 months, or both the fine and imprisonment. The National Consumer Tribunal may also impose an administrative fine in respect of prohibited or required conduct. An administrative fine may not exceed the greater of 10% of the respondent's annual turnover during the preceding financial year, or 1 million rand. Ladies and gentlemen, this is just a small snippet of the CPA. It is a vast act containing a number of obligations on businesses to comply with. If you would like to check in on your CPA compliance, please feel free to pop me an email for a free risk assessment to see how we can help you. Thank you. I'm going to move on to Sam for questions.
Thank you. James, do you want to stop sharing our screen there? I see some questions have come in, and then we can tackle them.
Okay, so you got the questions. So who's going to be brave enough to answer them? Who's going to start first?
I'll start. We note that you mentioned cold emails. How does the POPI Act apply to the endless cold telephone marketing calls? So cold telephone marketing calls are both regulated in terms of POPI and the CPA. So I'm going to leave the CPA. You can touch on the CPA. I'm just going to touch on POPI. So POPI's marketing provisions in terms of section 69 refers to electronic marketing. So POPI's marketing is controlled emails, text messages, and there is also faxes still listed. I don't know if anyone's going to market via a fax, but a fax is in there and an automated calling machine. So you can't use one of those channels, so your electronic marketing, without consent. When it comes to telephone marketing, it doesn't directly regulate it. Here it's going to speak to where did they get your information? Was it collected lawfully? So if you're getting all these calls from people who you've never spoken to or never consented to, you're fully entitled to report them to the information regulator. And they will take it further. If you're like me, I simply on the phone ask them where they got my personal information, because I'm entitled to know in terms of the POPI Act, and very quickly they put down the phone and stop calling me. But really that's the area cold telephone marketing will link with POPI. It's where we're getting that information from, if we got it from a lawful source, and then if we're using it in terms of the consent that we have. In terms of how the CPA kicks in here.
Awesome. So with relation to direct marketing in the CPA, it's mostly regulated around what you get from the direct marketing. So if there's any services or product that end up being supplied with after that direct marketing. But especially in relation to cold calling, one thing that is regulated in terms of the CPA is when they can contact you. And there's certain, if I'm not mistaken, it's Monday to Friday, and I think it's between 8 and 5, if I'm not mistaken, sorry, I stand to be corrected, that they can actually contact you, and you may not be contacted on Sundays or public holidays unless by agreement. So it's very important that when you are signing, certain documents, when you sign up for things, they'll say, would you like to receive direct marketing material? Look out for those little blocks that say, can we contact you at any time? And understand your rights before people contact you, or require you to give them permission to contact you outside of those regulated hours.
I think you can answer the last question there while you're talking about the CPA. How does the CPA help businesses? That's a good one. It's a very good question.
It is a very good question. I think with the CPA, remember, a business in itself is also, because it can apply to juristic persons, a business in itself will also be a consumer. It really applies to everyone in the supply chain. So when you yourself are perhaps a distributor of a particular product or service, or product especially, and you're getting those products from somebody else, the CPA would apply to you still as a company. If you're receiving defective products from someone, you can go back and say, hey, I know it wasn't in our contract, but in terms of the CPA, there is an implied warranty of 6 months. Look at what you've provided us with. So yes, it is more towards the consumer, and it was put in there to really help defend consumers, because all we really had at that point was common law. And you'd see a lot of companies saying no exchanges, no refunds allowed, or no, you can't come back if something's broke. And that's really what the CPA was put in, to kind of regulate all of that. So I wouldn't say that it's not beneficial to businesses, because it definitely is, especially if you're a business who provides product to others. You would also seek protection from this very same act.
Okay. James, do you want to do The next slide.
Yeah, so if you look at the purpose of PAIA, sorry, let me actually just read the question. I don't know if you guys can see the question. So the question is, under what conditions would you generally request access to a PAIA manual? So if you look at the purpose of PAIA, the purpose of PAIA is to promote transparency as well as to give people the right to access information that they've got the right to access. So essentially, if you're doing a PAIA request from a private body, typically it's not a positive thing. But if I need evidence from a company in order to proceed with a CCMA case or whatever the case may be, that is typically the situations that I would then be putting in a PAIA request to access information. I don't know if there's any more information that you'd like to add on that.
Yeah, I think just to add to that, PAIA hasn't been a popular thing. Yes, PAIA has been around for much longer than POPI, but in my legal career, when I was a practicing attorney, I did one PAIA request, and that was the only PAIA request I ever saw. And I was requesting access to the financials on behalf of a shareholder. So you will use PAIA to try and force one of your rights. If I want to take LabourNet to the CCMA because they maybe didn't appoint me when I applied for a job, I can request the recruitment records to go lay an unfair labour practice at the CCMA. That's why James was saying it's generally not a positive thing when a private body gets a request, because someone is looking to enforce a right against you. Enforcing a right against you is a fancy way of saying they're going to take you to court, the CCMA, the tribunal, somewhere. They want something from you, a pound of flesh, but you have the documents that they need to prove it. And with PAIA, we must promote that access to it so we can all have fair rights. Yeah, anything else?
Yeah, the whole subjects are so complex. When we started off, it's all about, we thought it was just about the telephone call we don't want, the email we don't want. But as you've gone into it, it is so almost complicated. So I'll ask the simple questions like, is there an idiot guide to do this? And how do we go about it? So each one of these processes, most of us, I'm having a look who's online here, and a lot of people I do know, so how's it, everybody? Ask those questions, because now's your opportunity. Is there such a thing as an idiot guide where we can go and set up these things? Or is it a process you don't want to jippo?
This is a process you don't want to jippo. So I think one of the biggest things we're seeing, and I'm speaking mainly from a POPI and a PAIA perspective, CPA has been around. CPA tends to come back and bite businesses every now and then, but it's not the main focus right now in the industry in this data protection. It really is POPI and PAIA. And if we look at the last webinar that the information regulator held that we attended, they made it quite clear that if you are going for paper compliance and not inherent compliance, they're going to catch you. So I would be a little bit careful of trying to just jippo the process. The process, it is frustrating. It feels like now we've got more red tape as businesses to run, particularly the smaller guys, because they're not excluded from having to comply with POPI. But if we all play ball, it's going to be a lot easier for everyone, because yes, we've got to protect other people's information, but our own information we also want to protect. So if we all sort of work together in this, it will actually, it's going to benefit us in the long run. And particularly if you're trading overseas. The GDPR has been around for a while. That's Europe's data protection legislation. A lot of pressure was being put on us as South Africa to actually have something like this so we could trade internationally. So more and more, we are seeing international businesses put pressure on local businesses here as well. We are also seeing with tenders that you need to have your POPI documents attached to your tender. So you're not even going to be able to tender without doing this. So there's not really an idiot-proof guide because of the way POPI is. POPI is a principle-based legislation. So it gives you those objectives, and we got to figure it out somehow. There's a lot of information floating around online. Just be careful where you're getting your information, because some of it is very wrong that I'm seeing. And I think things are going to change as we go. There's a lot of grey areas in terms of POPI. I'm looking forward to the court cases and things like that, because we're actually going to start getting clarity on which way to move. A lot of what we're doing now, not just us, the country, we're playing guessing games. How is this going to be interpreted? So what we've done at LabourNet is we've looked to international legislation to guide us on how we implement. That's why I keep harping on about international best practice and trends, because I'm pretty sure our courts are going to stick with international best practice and trade. So that, I think, is the safest way.
In my conversation I had with Johan about the subject, he mentioned, like, casually, what kind of fines can be implemented. You mentioned in yours there were things in place, but when I heard it, it was quite scary. So maybe if you just tip on it, and it'll make people take you more seriously.
So in terms of POPI, the information regulators are governing body, as I've said. The information regulator has full power to fine you up to 10 million rand. There is obviously a criteria they're going to look at, how serious it is, but the body as themselves has that power. They don't need to go to a court to do that. They can just give you an administrative fine up to 10 million. There is, however, criminal sanctions in POPI as well. So with POPI, you could be looking up to 10 years imprisonment, but that's really reserved for the serious things like fraudulent documents or falsifying records, the things that were generally criminal practice to start with. But then, interesting enough, in terms of PAIA, if you willfully disregard the need for a PAIA manual, your CEO can be looking up to 3 years in prison just because you don't have one. And then, as mentioned with the CPA, it's 10% of your turnover or $1 million, whichever one's lower. But even the CPA has said, if you share personal information or give it out when you're not meant to, 10 years imprisonment for that act. And that's under the CPA, not even under POPI. That's why, as a regulating in our department, information compliance, we handle all 3 areas of these in one, because they're so interlinked. It just makes sense to do them in one process. Otherwise, it's somewhere you're going to drop a ball and there's going to be a fine or a penalty. I see we have another question. Where do you start in putting these various compliance structures in place? Sure. Yeah, that's a good one. Where do we even start? Right now, my biggest suggestion would be get a PAIA manual done, because of that imprisonment that's floating around. And I know the information regulator is going to start looking at our websites to see if we've got one. So get a PAIA manual, put that on your website, okay? There's lots of PAIA manuals also on the internet. If you Google one of your favorite companies, they'll probably have a PAIA manual, and you can look at it there. And then next step, I would get your consents in place. So if you are in possession of information like children's information, get the parents' consent. Biometric information, get the data subject's consent. That would be the very, very first. So PAIA, and then your consents, and then you can start building on your security measures internally. But I think those are your 2 biggest risk areas. So.
And the information officer registration.
Oh, yes. And register an information officer, very important. What did you
If I could just jump in on that. So a lot of people, I think especially when they heard like, oh, POPI, everyone needs to be POPI compliant, everybody rushed to the internet and started pulling all these policies and being like, oh, we're going to have this policy in place and we need to get this policy and this is what we're going to do to make sure that we have everything. But it's not just about implementation. And that's something we've been seeing with a lot of people. Oh, no, I have the policy, so I am compliant. It's not just about having those things on paper. It's about practicing it within your business. It's about training your staff so that they understand their expectations. It's about keeping up to date. POPI is brand new, and with every legislation, we constantly seeing amendments and changes. It's still in its teething phases, and we keep getting teasers from the information regulator of what's to come. So we definitely know there's more to come. So I think the approach of POPI being just this once-off implementation is definitely something that South Africans have to change, because I think we were all at that stage when it first came in, but we really have to look at it as not a project, but a program, because all that's really happening around the world is technology is improving, businesses are growing, more data is being captured, and all that's going to happen is we're going to have more regulations come in. POPI is just going to get beefed up a little bit more. So apart from implementation, actually just managing your compliance is also extremely important for companies.
I think, that's a very, very good point. A lot of companies think this is a once-off exercise. We tick some boxes and we are done. It's very much not so. It is a continuous process. Even in terms of LabourNet's POPI compliance, I sit on the committee, and we're constantly, every time we meet, every month, there's something new we're doing with POPI. And we've been POPI compliance already for 3 years. So it is a continuous process. I kept saying last year in my webinars that you can go to sleep being compliant and wake up non-compliant, okay? Because one change in your company, your CEO resigned, you don't register a new information officer. That's a breach. So all these little things, we need to keep our eye on constantly and make sure we're managing that. We look, since we've launched our product here at LabourNet, we've done changes to PAIA manuals twice because we had a regulation change. We've done constant updates to policies because things are evolving. So particularly now, you need to have an ongoing look at this. I see there are a couple of questions about whether LabourNet can assist with this type of thing. We definitely do handle all three of them. We have given out our email addresses, but I think the easiest one is poppy@labournet.com. If you have any questions, we can help you out and we can look at what we can do for you, because we do this on a retainer basis for our clients because we know what a hassle this is.
Like Wendy, just to add on to that as well, you know, like looking at it from a small business perspective, I understand that the fee can seem like a bit of a pain to pay a small fee every month. But if we look at where the world is going, it's all online data and data protection. So this act is going to, you know, become more and more developed and built over the years, and paying a small fee to a company such as LabourNet to assist you and manage your compliance, it still works out cheaper than firstly getting fined and secondly hiring an internal resource to do it on a constant basis. So I hear where you're coming from, but I think we need to look in the long run. This is the direction that the world is going. You know, everyone is upset about privacy rights and how companies are utilizing their privacy, and you know, companies are going to need to start clamping down in respect to that.
And I think one of the biggest stresses, particularly for our clients, is what happens if they go under an investigation. And that's why we developed this product that we have at LabourNet based on what our clients asked us for. And I think that's a big fear for everyone. What happens when the information regulator walks into your premises? Because they've got full right to get warrants from the Madge Court. They can sort of act like SARS. Just come in, start picking up computers and servers because they have a warrant. So that's also a process that we're trying to ensure is avoided at all costs, because it is quite a terrifying process at the end of the day. But once you sit with POPI and you start grappling with it, it goes. It is a lot, and I think the biggest thing, it's new, so we're all not used to it, so it's overwhelming. But as you get more accustomed to it, it's going to become easier and easier. And if you start now, by the time all the new regulations come, you will already be up to scratch.
I see there's one question that we did leave out here. Do we have a fee that covers all three areas? So our information compliance product does cover all three of these areas. We tackle it in a phased approach. So we first tackle what I like to call the risks, your main risks, your radar risks. That's completely in blank. Your radar risks. So information officer, get that registered first. Get your PAIA manual on your website, your privacy policy, and then phase out all of the rest as the risk kind of factor drops down. So yes, we do have a product that covers all three.
Perfect. Let's see what other questions we have. What is included in personal information? Personal information is really anything that relates to an identifiable living natural person or an identifiable existing juristic person. So anything, name, age, sexual orientation, religion, ID number, email address, so much. Anything that can identify a person. What is interesting to note is if a company's been liquidated, POPI doesn't apply to it, and if the person has passed away, POPI doesn't apply to it. So your executors won't be running around trying to get consent from people, because obviously we can't ask for consent in those situations. Okay.
I think we've caught up with them, hey?
Yeah, maybe just type. Yeah, POPI. And we're just giving the email address on the question, Wendy. It's poppy@labournet.com. That's the easiest one to use. And that will get through to us. I think we are done.
I think we basically another one.
What else doesn't apply? Just go down. There was a sneaky question there. What else doesn't POPI apply to? Sure. POPI is going to apply to a lot. if you look at the way they've defined things in the definition section of POPI, they are catch-all provisions. They're trying to make it as wide as possible so everything fits into it. Even if you look at the application of POPI, POPI is going to apply to you if you are in South Africa and processing information in South Africa. If you are outside of the country, but you process here, let's say you've got a server or something in the country, POPI is going to apply to you. So the moment you have some presence in South Africa and there's personal information being used, POPI is going to apply, which is a little bit different like to our European counterpart, because in Europe, even if they're here, we have to protect Europeans' information under the GDPR. We just extend to our own borders. Okay.
If I can just jump in there, I know we're asking what doesn't POPI apply to, but along when you put in those policies to help you with your POPI compliance, you'll see that those policies protect a lot more than personal information. When you start putting in processes as to who has access to what information within your company, you're also dealing with things like trade secrets, things like that, blueprints of something that are kept somewhere. Do you guys actually have policies in place as to who can access the office that certain things are kept in? So POPI compliance in itself actually helps you protect a lot more than just personal information.
Yeah, it really, really does. Implementing POPI properly actually helps you run your business effectively as well. So it is great to have. If you address a situation where you have misused personal information, but rectify it ASAP, can you still be in trouble with the Act? Yes, you can still be in trouble with the Act. It depends what you've done with that information. If it's accidentally leaked, we have to report that to the information regulator. If you somehow have incorrectly used personal information, that may be able to be fixed internally so it doesn't actually get out, but it really just depends how you've misused it. So definitely if the last data breach I'm aware of from one of our clients was an employee sent out a conference list of all the attendees to a conference to everyone in the conference. So everyone got access to everyone's ID numbers, home addresses, email addresses, that situation. If they've taken measures to try and prevent it, they won't be in trouble because accidents happen. But if they've done nothing and did that, they're going to be in trouble. So it's also really about how much effort you put in to try to prevent these mistakes from happening. If you've put in effort, you've got policies, you've tried something, you'll be fine. You have nothing in place, the information regulator will come for you. Okay. I think that's all of our questions.
And you won't believe it. It's almost been an hour. Can you believe it?
No.
But you know what?
Yeah.
I think everybody has learned a hell of a lot, because we come in and our mind is set on POPI, phone call POPI, SMS, POPI, that. But when you go into exactly how in depth it goes, I mean, everyone's asking, is this going to be recorded? It is currently being recorded. So you can go into the KZN Top Business YouTube channel and it'll be there for everybody to view and view and view again. Because if you go through all the notes that were put up there, it's almost like a lecture. You've got to go back and read it again. Too much information for me. And I bet you too much information for everybody else. So go back and watch it. And I can assure you we're going to have another session later on where we'll just take a specific angle of what we've spoken about and go into more depth in it. So from the three wise men or three wise ladies or the three wise, whatever you want to be, it's an incredible session and I loved it incredibly well. So James, Jana and Samantha, thank you very much. And Johan, I know he's sitting on the panel. Johan, thank you for providing the information. It is absolutely incredible. And in our meeting we had earlier, when I did a coffee with Johan earlier, he mentioned that you do bespoke packages. So somebody mentioned about cost and X and Y and Z. Nothing is unaffordable when you're looking at the consequences of what could go wrong if you don't spend it. So have that conversation because it's absolutely worth it. So from Grant Adlam here at KZN Top Business Masterclass, I bid everybody a wonderful week and we'll chat soon. Any comments before we tune off?
No, thank you for having us. It's been a great session. I'm sorry it was a lot of information. We did try to cut it down, but we look forward to engaging with everyone in future. Thank you.
All right. Cheers, everybody.